Hi, everyone. Thank you very, very much for joining today. My name is Kyle Melville, and I'm part of the Young AFSA Knowledge Subcommittee. I'm an associate in the Disputes and International Arbitration team here at HSF Kramer. Um, and I'm just here to introduce our two speakers today who will help us unpack the important topic of research in arbitration, and that is Andrew Russell and Vincent Bashur. Andrew is an advocate at the Maisels Group of Advocates and has experience in both front-end project and energy agreements, as well as dispute resolution, including adjudications, arbitrations, and litigation. Vincent is a content manager for the arbitration, litigation, and mediation team at Wolters Kluwer and holds a master's degree in history from Leiden University. Andrew, thanks so much. I know you'll be kicking us off, so please, when you're ready.
Thanks. Welcome to the end of the month, everyone. Imagine for a moment you can feel your salary jingling in your pocket, and your first big break is about to happen as a young practitioner. All right, let's keep that image. A mega client walks into the room. Your firm has landed a new matter for its biggest and most important client. Your client is being sued for hundreds of millions in arbitration. And your senior partner looks at you and says, "You're the lead." Client looks at you in the eyes and asks, "How will the arbitrator decide this matter?" You need answers. You need to be cool, calm, collected. And you obviously have all the answers, right? You want to be Harvey Specter, but you're feeling like Mike. What do you say? What do you do? Where do you even start? Okay. Hold that thought in your mind as your throat dries up and the client's looking at you and you start to sweat and your heart is pounding. Keep that feeling for the whole of this presentation. And the person who will make it go away is Vincent. So let's start with the basics. We'll warm up first. What is arbitration? We all know what it is, but let's just go through a couple of bullet points. It's a system to resolve disputes out of court. And we know an impartial arbitrator makes a binding decision. That's why it's important. Hundreds of millions of rands at stake, and your client wants to know what's going to happen. It's done by agreement between the parties, so the parties have agreed not to go to court. And that final bullet point is important for us as young practitioners. Arbitration offers greater confidentiality. Now, that's good for the clients. They want to keep this kind of matter out of the public press in court. But particularly for young practitioners, confidentiality can present a problem. It means arbitration awards are not made public. They don't set a precedent. And as we know as young lawyers, this is the young AFSA branch, like cases must be decided alike. That's the whole point of precedent. And I think it's particularly disadvantageous for young practitioners like us, because skills need to be transferred. It's easy for Harvey Specter to know exactly what's going to happen and to clench that $1 million deal and win the case. But how do we learn? Who do we ask? Feel a bit like John Travolta. I don't know how the arbitrator is going to decide this matter. It's very complex. You can't exactly ask the arbitrator. I mean, you might ask around, but that's not good enough. It's not like what we've learnt in, I see I've got a question. Oh, no. Okay, let's do questions later. But if everyone can hear me, we'll do questions later. But the point is, we need, as a young practitioner, you sit there, this client is staring at you. He's paying lots of money. You're the lead. And you need to essentially navigate without a map. It's not like high court decisions or what we learned in law school, where we can find the case law on Safley or on LexisNexis or on Juta. We come back to that first problem, which was arbitrations are confidential. So we don't know what previous arbitrations have decided. Now, let's get back to our practical example. Remember, your throat is dry, you don't know the answer to the question yet. And you say, okay, well, tell me about the matter. It turns out it gets more complex. It's a large construction project in South Africa to build a coal mine. Complex engineering, many different disciplines involved. Different disciplines means different contractors working at the same time on the same site. And of course, there will be disputes. And now what you learn is that there are different arbitrations running in parallel before different arbitrators on the same project, involving overlapping issues and problems across the different arbitrators. You can't access the different arbitration awards before the different arbitrators. It's not like precedent. You can't find out what is being decided on this matter. And essentially, you cannot learn or find data on your particular matter. You might hear things in the corridors or what you hear around, but that's not good enough. It's not data. And it can feel a bit like this picture. Facts, decisions. You know these arbitrations are happening, but you don't know what's being decided. You don't know what arguments are being advanced. You don't know what arguments are working, what arguments aren't working. And it can be very, very difficult, particularly for young practitioners. So let's look at some of the resources we have available to us, because doing nothing is not an option. Remember, the client's looking into your eye. You can feel your chest pounding. You have to do something. Nothing is not an option. So the first point of call that we have is local case law. Some reported judgments deal with arbitration. For example, applications to review an arbitrator's award. So an arbitrator gives an award, it's not appealable, but there are very limited circumstances where a court may intervene and set it aside. The problem with that is it provides a view from the outside as to what happened or what went wrong in an arbitration. The problem is that there are very limited issues and it's quite fragmented. It's difficult to see the whole picture. It's difficult to understand what happened in that complex arbitration that you need data on if you can't read the award because the award is confidential. Court judgments on arbitrations focus on very limited issues. For example, did the arbitrator decide what they were tasked with? In legal speak or parlance, we say, did the arbitrator act within his or her jurisdiction? But this is a very narrow point that the High Court may consider, and it won't tell you enough about everything in the arbitration. You might be able to pick out fragmented bits and pieces. for those who are interested, I think one of the leading cases at the moment on this is close-up mining in the Supreme Court of Appeal 2023. If you read that judgment, you'll see that you can catch glimpses of that arbitration, but you can't understand everything about it. What we also have, but not in South Africa, are redacted or sanitized arbitration awards. So some arbitration centers publish redacted awards. For example, the World Bank ICSID database has awards that are published, and one can search those. If I click on that, I'll take us to it, and I'll start to share again just so you can see what it looks like. So this is the ICSID database. And here we do have a database of decisions by this body. So it's the World Bank body of arbitration. And they've got quite good search criteria, and the database is extensive. I've linked that in my presentation notes. Let's go back. So the difficulty we have, of course, is that these are redacted awards that are not necessarily relevant to South African arbitration institutes. For example, AFSA doesn't have something similar as far as I'm aware, and the Association of Arbitrators equally doesn't have something like that. And since we are speaking to the body of the young AFSA, the final bullet point on this is, well, that's a problem for us as young researchers, but perhaps it's an opportunity for young AFSA to start generating something like that. Now I just need to get back to my slides. Of course, another tool that we use is Google. Google is a powerful search engine with access to a lot of databases. Very often, my searches for arbitration decisions or parts of arbitration decisions starts with Google just because it is such a powerful search engine. But that also has its problem, is we need to spend a lot of time filtering the results. And as we know, when you search in Google, you can spend hours and hours and days finding irrelevant results. I come back to that initial point. We're feeling around without a map. And one of the questions I have, and maybe Vincent will touch on it later, is anybody using AI for arbitration research? I'm on the older end of young AFSA, so I haven't picked up AI just yet, but I'd be interested to hear what everyone else is doing. Then, of course, we have legal databases. South African arbitration law, how we run arbitrations internally, leans on English law. And that's good for us because it opens up international databases such as Westlaw, LexisNexis, and Wolters Kluwer, where Vincent is from. So let me give you a practical example that I recently had to deal with. The brief seems simple at first, but bear in mind we're dealing with a complicated and prolonged arbitration. Your partner at the law firm looks at you and says, right, we don't have time to do everything together. You need to deal with this aspect. I want you to draft detailed submissions on arbitration costs. and you need to be persuasive. Now, where do you go? Well, first port of call, Arbitration Act, but it doesn't really tell you the answer. All that the Arbitration Act says is that an award of costs is in the discretion of the arbitration tribunal. Okay, I can't exactly say that to the tribunal. That's not convincing. All that's saying is, well, Mr. or Miss Arbitrator, you have the decision. They know that already. The AFSA commercial rules make my job even more difficult in a sense. The arbitrator has the widest discretion and power to award costs. Okay, we understand. But what do you say to the arbitrator? You've got to convince them that they should award costs. You need to present an argument. What should the costs be? Now, because South African arbitration law relies on international arbitration law, we can look to resources as to what is the best practice internationally. So let's go back to our example. You've now been given a specific task, complicated construction engineering arbitration. It's been running for weeks. The costs have racked up. There are 18 lever arch files sitting on your floor in your office, or gigabytes of data. Everyone's been burning the midnight oil. The timers have been running. How are you going to deal with costs? You need to make the submissions to the arbitrator. Well, what is the best practice internationally? Where do we go to? You're in this universe with no map. Well, you ask the best, right? You could try asking these guys, the Hitchhiker's Guide to the Galaxy, but they won't exactly give you the answers. The Hitchhiker's Guide to the Galaxy will tell you that in many of the more relaxed civilizations of the outer eastern rim of the galaxy, the Hitchhiker's Guide has already supplanted the great Encyclopedia Galactica as the standard repository of all knowledge and wisdom. And it'll also tell you that a towel is about the most massively useful thing an interstellar hitchhiker can have. Okay, it's a bit of a joke, but don't panic, because Vincent does have the answers. Now, let's ask the best in our industry. You might have heard of him, you might not. Authors such as Gary Bourne have written extensive textbooks on international commercial arbitration. He is the mega rock star of international arbitration. For the younger viewers, he's the Ed Sheeran of arbitration. For maybe the slightly older ones on this call, he's the Bruce Springsteen of international arbitration. He's so authoritative that you will find all over the world courts citing Gary Bourne as authority. And his work is truly massive. It's a massive database comparing how different tribunals around the world have thought about and decided issues, and in this instance, costs. So we've still got our brief. We need to write submissions to this tribunal and make submissions as to how to award costs in this complex arbitration. Your client's looking at you for the answers. All that the Act and the rules tell you is that it's in the tribunal's discretion. But that's not very convincing. How can we learn how the best tribunals in the world exercise their discretion? Well, Gary knows. And what I was able to take from Gary, and the tribunal's happy, the perfect answer is that the general rule is that the loser pays. Tribunals take into account various factors. Was the claim excessive? Did the parties conduct themselves reasonably? This is a good one. Did the lawyers make it needlessly complicated? Did your client reject a reasonable offer to settle? Did you, as the legal team, use delaying tactics? In this example, I could write up my submission on costs and take a definitive document to the tribunal and say to them, look, this is the best practice, citing Gary Bourne. And the tribunal was very happy. To show you just how extensive this type of research is, I scanned a copy of Gary Bourne's book to see, just to show you the depth of knowledge in this type of database. So I found the answer to costs on page 3,351, which is a staggering number of pages, and that was only in volume 2 of 3. But it's quite incredible the knowledge that is available to us as younger practitioners. And remember, I said the only answer we had from the local authorities or from the Act and rules was, well, the tribunal has a discretion. But this text was able to show us, what do the best tribunals in the world generally take into account? And I've highlighted some of it. It was what was claimed. Was it reasonable? Did the lawyers make it needlessly complicated? And Gary Bourne cites, you can see the magnitude of the footnotes, cites ICC decisions, quotes from them. A large amount of time is spent that did the party behave unreasonably? For example, rejecting an offer to settle. It's not only the result of the proceedings, it's the behavior of the parties during the proceedings. And he also cites a case where, or an ICC decision where a party claimed excessive damages. Remember, you go back to your client and they say, we want as much money as possible. Well, these are considerations one needs to take into account. And texts like this assist us younger practitioners in finding a way to carve out a persuasive answer. So there are also other authorities on the topic, and you can jot them down. They're not from Vincent's stable, but I'll mention them anyway. Mustel and Boyd is an excellent textbook on English arbitration. And we also use another text called Redfern and Hunter. But time and time again, I come back to Gary Bourne because thus far, and I don't say I know all the answers, but thus far in my practice, Gary Bourne's book has been the one that covers many different jurisdictions. He cites cases from the USA, England, Singapore, Hong Kong, all of the major centers. And you can collect that, you have good data, and you can go to a tribunal, especially as a young practitioner who wants to carve out your career with this big client. Go to the tribunal and say, I've done the research. This is how you should decide it because all the other tribunals around the world are deciding based on these factors. Of course, you'd need to apply it to the facts of your case, but the point is that the research can go much deeper than simply saying the arbitrator has a discretion or that costs are in the follow the result of the arbitration. Now, this is a small example, but quite often as young practitioners, our role starts off small, and if we do well, it gets a bit bigger and a bit bigger as we get more responsibility. And I think the steps we follow, if we can refine those steps now while we are young practitioners and carry them forward, Well, when we are responsible for the hundreds of millions of rands, or maybe even dollars, then we'll have done our job. And so, in summary from my end, you don't have to be Harvey Specter yet. You don't need to have all the answers now, but you can certainly find all the answers. And to help guide you through that confidential world without a map, I'm going to hand you over to Vincent from Wolters Kluwer, who can now give you a very practical example of how to actually use the tool. Thank you. Vincent, over to you.
Thank you, Andrew. Let me share my screen. So as Andrew was saying, Kluwer arbitration is one of the most recognized sources for international, commercial, and increasingly also investment arbitration. The focus of this database is international. So domestic arbitration is largely out of scope. And originally the database was conceived as being a digital representation of Kluwer's books and journals on international arbitration. Over time, that's been expanded, and we now have an excellent collection of books and journals, but also increasingly online content, online solutions that you would not be able to find in your library if you still had one. So for us, the basic principles are you start off with the contract, you can have a look at the jurisprudence, and you can have a look at the analysis of the jurisprudence, as Andrew pointed out, that is not readily available by our experts. If I recommend clients to, lawyers who need to start using this database, I would always refer them immediately to, if they have a dispute, to start off with having a look at what do the national rules, the national law, the institutional rules, what do they dictate, and then proceed from there. So what we have in our database is, as I mentioned, books and journals. And one of the books that I will refer to quite often is the ICA handbook. And we've even included a shortcut to it. I'll show you how to get there from the books list in a minute. But in this publication, which again, I cannot recommend highly enough, for over 80 jurisdictions, you will find a national report which analyzes in a very structured manner the arbitration situation, if you want to call it that, within a country. And at the same time, you will also find here for the same jurisdictions the most relevant arbitration acts, the Mediation Act, etc. And South Africa is, of course, present. The other thing, as I mentioned, is you can go into this books list and find it by title, the International Handbook Commercial Arbitration. This list of books is all of the treaties that Kluwer publishes, but also a lot of other publications. Redfern and Hunter, in fact, not published by Kluwer, but is included in the database. And that indeed for English and international law or international arbitration is a highly regarded publication, and we have the latest edition. We also have Gary Bourne in the database, which, as Andrew mentioned, is kind of our arbitration Wikipedia to start off with, to get you started. For each book, once you've gone into a book, you can use the table of contents to navigate. You can also search within this publication. I recall that Andrew was looking on cost, I think. And if you click on that, you'll be taken exactly within the actually it was costs. You can see that actually if you just type in the word cost, there is so much more. But the main section that Andrew was highlighting was chapter 23, where you have that focus on awards. And you can use the arrows to navigate through the publication. The range of publications in this database is huge. So we also have publications that focus on costs as a whole. This is a publication on costs in investment arbitration, but again, that can be expanded to commercial arbitration best practices. The other thing that we have, of course, is our collection of journals, which work in very much the same way as the books list. So here you can find journals by title, and you can sort them by the date upon which they were updated. You can find publications or articles within these journals or within these books that, written by particular authors or focusing on a particular jurisdiction. And that is the way that normally people would use the books and journals segment, which is very much, either you have a topic in mind or you have a reference that you want to go to, and that would be the way that you can start off. Browsing is one way, but of course, searching is another. So again, if you wanted to go straight to Bourne, you could type in Bourne. There's a link almost immediately to his publication, because we recognize that it is important. If I did the same for costs, you'll see that we have suggestions for costs. Again, the book that I mentioned before has costs in the title, so that pops up. And we, in fact, also have some solutions, which I'll get to later, which I've generated specifically with young practitioners in mind as a kind of starting point to research particularly aspects of the arbitration process, whether it's a request for a notice of award, to rendering the award, to hearings, all of that. All the ins and outs that come into that are dealt with in our practical insights solution, which I will follow on in a minute. Now, the important thing to realize is that this is still a 20th century database, and so querying like you would in AI is not yet possible. Having said that, AI is very much in our minds. And at the end of September, we hope to launch the first of a suite of AI enhancements that you could not just type in keywords, but actually start asking questions, and the questions would guide you to the content within the database. For now, I wanted to take an example of bias and challenge. Using both the and asterisk Boolean operators that are defined or explained in the help menu. Again, I can see that there's a book on bias challenges, which is helpful. But if I go in, you'll see again a book. That pops up as a recommend as a starting point. But then you get all the documents, the chapters, the awards, the court decisions, the rules in this database that refer to both the concepts of bias and challenge. Now, this, of course, is a ridiculous amount of content, so you want to try and narrow that down. In the concept, in respect of the concept bias and challenge, I'm guessing that you want not just both concepts in a document, which could be anything, but you're looking for a relationship. And you see that if you're looking at challenges, maybe challenging an arbitrator or challenging an expert, and you want to do that on the basis of that person having a bias. If those two words are near to each other, are they in a certain paragraph? Are they in a certain sentence? The relationship between those concepts becomes much more narrow. And you can use Boolean operator to really narrow down the relationship. And then subsequently, you can use the different filters. So we have here, let's call them content type filters. Am I looking for court decisions or awards that discuss bias, near, challenge? And you can also use other search filters to really narrow down the search results that you get, so that you can get from 400 to maybe 20 that you can then scan through. The URL of each search is unique, so if you want to save that in your files, in your dossier, then copy that URL. Alternatively, there's an option to, again, copy the URL through the URL button, or if you still use them, an RSS feed, so you can be notified when new content is added that meets your search criteria. You can select individual documents or select all of them and then either download them, print them, share them, although beware that the person that you're sharing it with needs to have access to clear arbitration. And you can revert to this content later in your research. So again, we started off with having a look at the law, having a look at the ICA handbook to see what the law means in a more developed, to give you a more developed picture. And we have the publications that can offer you additional insights. As I mentioned, in addition to books and journals, we've increasingly been focusing on getting you more and more content that is not necessarily derived from books and journals. One of the things that we've been focusing on increasingly is our collection of arbitral awards and appointment data. So we have cases where we have been able to reconstruct through databases such as the ICC and ICSID, any type of composition of a tribunal, of a case. We may not have the decision, and you can actually search cases where we do have the documents as opposed to where we do not. But in total, we have about 1,700 decisions in a varying number of cases. And you can use this page to narrow down the selection. So again, you can say, I want cases where certain rules were applied, or cases administered by a particular institution. You can find cases by seat. Again, all of these parameters determine the relative comparability with the case that you're working on. And when you go into a particular case, you can see at a glance the information that we've enriched this with. So you can see the party names, the type of dispute, the status, the sectors, the rules, etc., etc. And you can see who represented whom at a glance across the dispute. And then additionally, if we have either information on proceedings or a document to support it, we will provide that. In this case, we reconstructed the information. We don't yet have this in this case or this decision, but the moment that we do have it, we will add it. But you can use this still to see, who represented whom across these different proceedings. Another thing that I very much recommend you using, especially if you're trying to compare a situation that you're more familiar with a situation that you're less familiar with, or you want to maybe try and give advice for your counsel, for your parties, what to put into a clause or how to proceed, what action. The handbook, because it's such a structured bit of content, we've actually developed a tool that you can allow comparative research. So again, if I wanted to see on costs, and then maybe I wanted to compare South Africa to maybe South Korea, seeing because you have experience with the situation in South Africa, but you're maybe less familiar with South Korea. And then we'll give you insights as to the situation and the legal background on the topic of costs in South Africa and South Korea, so that you have a better understanding of how that pans out, and you can change selections, etc., etc. It's, I find, really relatively self-explanatory. For an at-a-glance insight as to what kind of content we have developed jurisdictions pages. They're similar to using a jurisdiction filter on the search database. So again, if I wanted to go to South Africa, you'll have here a direct link to the national report for South Africa, direct links to our versions of the relevant arbitration acts, or some information as to which treaties. This is just a collection of 4 that we've done this for, but we're working on expanding that. And then you can see what else do we have. So we have 30 court decisions, 3 pieces of legislation, some commentary where an author in a book or a chapter or in a journal article specifically discusses something related to the situation in South Africa, and investment treaties signed by South Africa. So these are the most recent ones, and then by clicking on the More button, you'll get the rest. Again, this is just a way of offering you a quick access point. The same we also do for in organizations. And if there is a publication that we have on a particular topic, we'll highlight that again. And here again, you can see for the ICC, all of the awards in our database. So that's the jurisdictions and organizations tool. The practical insights that I mentioned before is kind of our way of making people familiar with a particular topic, a particular practice, or just giving you a reminder, because I think they're suited both for the juniors, but also for the more senior practitioners. So we have a huge range of topics, and this collection is growing. You can, again, use our topic navigator to see, okay, what's in it on costs. And then you can go into a practical insights page. They all look and feel and work the same way, in that you have an introduction section which highlights kind of, what is this about this topic, important considerations, things to consider, and then practical guidance on each and every step. And then, of course, in the international situation, we offer some links to key cases, key commentary in the database, and recent blog posts on the same. These pages generally offer a kind of global perspective. And then for a number of countries and organizations, we kind of take a little bit of a deep dive into how a particular jurisdiction or how a particular organization interprets this into their legal act, their legal provisions, and how that either aligns with or deviates from the more general practice described on the Practical Insights page itself. And again, these pages can all be used for more, if you're being asked to research something and you have literally no clue what's being asked of you. But I know that a lot of the more senior practitioners also use these just to kind of have a checklist kind of approach. Have I ticked all the boxes? Now, at some point, you also want to know what has a particular arbitrator said on a particular topic. That could be because he's your arbitrator, or it could be because you're seeking to appoint an arbitrator, or it's the counterparty's arbitrator. And maybe you also want to challenge that arbitrator. So what we have here is a profile navigator that is based off of all of the appointment data and the cases and the awards that we've collected in the cases and awards page. And this leads us to a page where you can find an arbitrator and have a look at their expertise, and also have a look at the awards that they have been involved in, anything that they have published that's included on Plural Arbitration. I didn't prepare this, so I'm just going to take the latest arbitrator that I spoke to earlier today. And you can see here that we have a profile of an arbitrator that highlights in a general way somewhat that person's expertise as demonstrated by the information available to us. And sometimes, in this case, Maxi has also offered some additional information. So there's also some self-reported information. And that can be used to gauge, again, whether someone is eligible, interesting for an appointment, but also because we have all of the awards, at least a collection of awards. I'm not saying we have all of them. We have a limited collection of awards, and we have a selection of their publications. You can research how that person has discussed certain topics in the past, either in their case law or in their publications. And below you can see the information available to us and the different cases, the relationships that she has with other people across these different cases. If you wanted to see, okay, maybe you want to appoint this and the counterparty has appointed someone, maybe Maxi isn't the right person for you. So I saw, for instance, Maxi, and I want to see whether she has a relationship with Louis Fortier. I can see that they have in fact had 2 cases together. One is concluded, the other is pending. And you can see here the different relationship or the different roles they played. And then from this, you can gauge whether, maybe appointing Maxi is a good idea or not. So that's a way that you can use this, this relationship checker. Again, you can fill in a name and then cross-check in our database whether that person has an established relationship with a law firm or an organization, with a state or with a commercial party. All of this information we try and gauge from the decisions in our collection. And the 2 last tools that I wanted to highlight in the time that I have left are the quick answers and the templates and examples. So the quick answers, a little bit like the ICA comparative tool, is very much based on a very rigid analysis of different documents, whether it's the national law or, in this case, the arbitral institutions, and the other 4 are based on national laws, including South Africa. So, for instance, you could say, if I'm looking at on costs, decisions on costs about the arbitration. Unfortunately, AFSA is not here, but let's say I wanted to compare the German arbitration institution with the Hong Kong arbitration institution. You could see that, how do their rules talk about costs? What are the implications, etc. And there's multiple topics on costs that I selected that for each of them. It gives you a little bit more insight, and that really builds this comparative database that we strive to achieve. And then finally, the last solution or tool, again, something not strictly derived from a book or a journal, is a templates and examples tool. This is very new. The intention is to develop this for a suite of arbitral institutions. So far, we've just launched 2, I should say. The 3rd one is coming soon, where for the various stages within the arbitration process, we offer guidance as to how to proceed, what to do, and more importantly, giving you templates which are vetted by experts, documents that people could use in the approach to this particular part of the arbitration process, in this case, the hearing, where you could say, okay, download this document. All you need to do is follow the instructions by the experts. They'll give you, a template, a structure to work within. They've also drafted comments or recommendations. Sometimes there's also an example, in other words, a pre-populated template from a hypothetical case, maybe some other materials, and then there's guidance and recommended reading, including, of course, Gary Bourne. So those are the tools that that we have at our disposal. And that is, in a nutshell, various ways in which you could use Kluwer arbitration to implement your research, to try and navigate, as Andrew called it, the limitless collection of data, unfortunately, which is not fully available, but at least this gives you a glimpse of what is available and what has been discussed either in practice or by experts. Thank you.
Brilliant. Thanks very much, Vincent, and thanks very much, Andrew, for both of your extremely practical and insightful presentations. I don't know if we have time for questions, and I can't see if there are any. Unless I'm told otherwise, I think that's all for the evening. So just again, to everyone who attended, thank you very much. Hope that you all found it as extremely insightful as I did. And then again, to Andrew and Vincent, thank you both for your time and for sharing your expertise.
Absolute pleasure. Thanks, everyone. Thanks,
Brilliant.
Vincent.
Thank you so much. Bye-bye.
Cheers,
Bye.
everyone.